Okay.
Okay, she left. I don't know where she went. Go ahead. I'll make
Okay.
her in when she
Okay.
comes. Go ahead. I just
Well,
want
I'd
to.
like to welcome Brian Kennedy to the broadcast. Sorry about the issues, Brian. But if you would unmute. Brian and I spent some time together last night working on this issue. Brian, I've been at the General Assembly all morning with Kim Bobo, our director, and we went to every subcommittee member's office, and we went to every member of the full committee, because I didn't realize it was subcommittee number 2 that would be meeting today. And we're very hopeful. We hope the team that's there, I know they're going to do a great job. But if you could you talk about CAFA and its history and why it's so important to us?
Sure. So I think you all have some background on this, but for anyone who doesn't kind of know where we are, what happens to someone when they get arrested and held in Virginia is as different in every county and city as the counties and cities are. So depending whether you're in Fairfax, where I practice, or you're in Galax, or you're in Martinsville, or you're in Norfolk, wherever you are, something different is going to happen to you because all the procedures are slightly different. But one thing that's pretty similar in most of the state is that most people who show up after you're arrested, you see a magistrate, you're held by the magistrate, you're held for somewhere between another few hours and a few days, and you finally see a judge, you are there alone. And right now, during the past 2 years, you're usually there on video. So video alone, no lawyer to help you. There might be a prosecutor, there might be someone from a pretrial services agency talking about whether you should get out or not. The judge may or may not make a bail decision at all. They'll ask you if you have enough money for an attorney. If you do, they'll say good luck. If you don't, they'll probably appoint you one. And then depending when your attorney gets notified, when the attorney comes to see you, and when the court sits next, then you might be able to get a bail hearing. And in some of our more rural jurisdictions, the court might only meet once a week or twice a month. And you might not be able to get a bail hearing for that amount of time. So in many other states, although not most states, and in some jurisdictions, individual cities or counties throughout the country, they've done what is really the best practice, which is to make sure that there's a lawyer for the person there the first time they see a judge, and that the lawyer knows in enough time that they're going to be on that case, that they have enough time to talk to the human being that they're going to be representing in a confidential space to get information, and that lawyer can make a meaningful bail argument, at a very least, a meaningful bail argument to the judge. And when I say bail, I mean a release argument so that the person can go home. In some states, there's more due process involved. They do a probable cause hearing, or the government has to give, a version of facts that the judge has to believe. There can be more than that, but really in Virginia, all we're asking for right now is the bare minimum, which is for there to be an attorney there, and for that attorney to be able to say this person should go home and not have to wait in jail. So that's the basic idea of counsel at first appearance. In terms of its history of the bill that's being heard today in the House and will be heard soon in the Senate, this I think is our third year, at least our third year of advocating for this bill. A wide variety of groups, including Justice Forward Virginia, that I'm a part of, and now Virginia Interfaith, among many others, that this bill basically started off a little bit more strict, but what it would do is say, hey, everyone in Virginia who gets arrested and held has to have a lawyer at their first appearance, whether that's the next day or 5 days or 10 days from there, whatever it is, and that each city and county would have to come up with a plan to do that. So the way it looks in large suburban counties or urban counties would look very different than small rural counties. Cities might look different than counties, but everyone would come up their own plan so that each jurisdiction would have the flexibility to work that plan with how their court works, how their jail works, and how kind of everything else works within the system. The past 2 years, the bill got started off in House Courts of Justice committee. It passed that committee, both the subcommittee and the full committee, both years. It has died in appropriations, which is the money committees, the past 2 years, mostly because the Office of the Executive Secretary of the Supreme Court of Virginia has initially said it would cost way too much money. They gave an absurd cost estimate. Last year, Delegate Krizik and Delegate Aird, among others, on a appropriation subcommittee, got a budget amendment put in that required the Office of the Executive Secretary of the Supreme Court to basically do a study about what counsel at first appearance would look like. The Virginia State Crime Commission also had the same recommendation, and that all basically got roped into one study. The study group was mostly judges from around the state. There was a public defender on there, there was a Commonwealth attorney, and there were some clerks, and I think some representatives of sheriff's offices as well. Haven't be that they run the jails, so they're logistically important in this. That group, we were disappointed with their report, although not surprised. Lots of things came out of it. It highlighted, and you can find it online, and I'll try to find it and put it in the chat. It highlighted some of the logistical issues that I think in some ways come from a lack of imagination. If you're trying to fit this into the way courts always do things, it might seem difficult, but if you just took 5 seconds and thought about how maybe we don't need to always do bail hearings at the same time we've always done them, we could change it up a little bit, it would make things a little bit easier. And they pointed out some other logistical problems that certain places would have to deal with. But I think one of the most amazing things in the report, and I think I'm getting this right, is that most people who get held get out at their bail hearing. That's certainly been true in Fairfax. We don't have counsel at first appearance where I practice, but we've changed it up, but it's certainly most people get out. And I think what they said, it would save something like 100,000 days of incarceration per year if you had counsel at first appearance. And by that, I mean, that's a human being sitting in a cage for a day. So for some people that might be multiple days, for some people that might be just one day, but that would save that many days of actual real life human beings' lives. And that was their estimate, which again would be on the conservative side, I would say. So that's the brief history. We're back again this year. Obviously, the landscape has changed a little bit, but one thing I do want to highlight here is that this should not be a partisan political issue. There's a lot of ideas for people on both sides of the political spectrum and everywhere in between that it would be good for. And I'm sure we'll get into those later. But we're hoping to have some success this year and try to gain back some of those real human life days that are being lost for really no reason other than kind of procedural quirks in our system.
Wow, that's a good background, Brian, a very good background. And I hope that today, while all of our colleagues are down at House Courts of Justice Subcommittee number 2, testifying and giving the reasons why this would be so helpful to the citizens and to defendants in the Commonwealth of Virginia. But it's up to this vote. There are 20 people on the subcommittee, and we hope we can get the majority of votes and continue this process in the House of Delegates. Ashley Mejias, how are you? And welcome to this conversation and to the panel. And please tell us what's on your mind today.
I'm glad to be here. My name is Ashley Mejias, and I am one of the co-directors of the Richmond Community Bail Fund.
Right.
So the work that we do is primarily on the ground. Our structure is very simple. We provide free bail to anyone who calls us. If we are able to afford it, we will post that bail. So we often are talking with individuals who are in the middle of this pretrial moment that this bill will allow for representation at. And I'm hopeful this bill, I think, brings attention to we often have people calling us and there's a tremendous amount of confusion around pretrial conditions. And we end up doing a lot of untangling what is happening with individual defendants so that they can be more clear about what's happening in their situation, and we can actually do the work of helping them figure out how to get released. That can look like anything from calling other jurisdictions to find out if they have a bond there, to explaining what like a GPS or a home electronic monitor might mean for these individuals. We often have to help communicate between the jail and court-ordered rehab facilities. And a lot of times what has happened is at the arraignment, it has gone so fast that they are unable to ask questions about what has been assigned to them, and they're relying on staff at the jail to explain things to them. They're relying on other folks who are incarcerated. So I think the human cost is not only that folks are incarcerated for longer, which you all may have talked about this already, but we know it's well established that that has horrific outcomes. It takes about 3 days for folks to lose virtually everything. But people feel obviously a lot of anxiety. Their families feel a lot of anxiety, and the court system and the incarceration system is not an easy one to decode unless you've been doing it for a long time, and most people have not. So I would be very, very hopeful if this.
Ashley, I'm raising my hand because something you said was so profound that it only takes 3 days for someone to possibly lose everything they have. Can you repeat that and speak to that again? Because I hadn't heard that.
Oh, sure. So a really important bit of information that needs to be repeated again and again when talking about the pretrial moment for defendants is that when pretrial and bail and this arrest is kind of like the front door to the entire mass incarceration system. And so when a person is arrested, what experts and activists and organizers and community members have found is that most of us who are experiencing incarceration, it only takes about 3 days for people to lose their job, to lose housing, to have family relationships fracture. And it actually is pretty common sense when you think about it, because you don't have access to communication. You don't have access to your funds. You're virtually cut off. And that has obviously a tremendous impact on our communities.
And Salim, if I could add a couple statistics on that point. So the like data actually really bears it out. So people who are held pre-trial, especially people who are low risk, which we can get into what that means, but people who probably should be released anyway are held. They end up with a 4 times greater likelihood of being sentenced to jail as when their case ends. Their jail sentences are 3 times as long. They have a 3 times greater chance of being sent to prison when their case ends. And they have a 2 times longer prison sentences. I'm going to see if I can share this because I think this is always the thing to me that that just blows my mind every single time. I'm not going to be able to do that. Sorry.
And I just want to, oh, sorry.
Oh, did you see the slide? Did it come up?
No. No.
Sorry, I'm trying
This
to share.
might be in your data, but I know that there's an increased likelihood when you're held pretrial of taking a plea deal.
Yes, as
So,
well.
and that's also a really important bit of information, I think, when we're considering what's happening in defendants' lives.
And I think I'm sharing a slide right now. So this is the craziest thing for me. This data is probably updated since this came out a few years ago. But even if you were not guilty, because a lot of people get arrested are not guilty of anything. If you are not guilty of any crime, but you are held for more than 3 days, 7 days, 14 days here, it shows as you're held for longer, so even 3 days, your recidivism rate overall and then over the next 2 years goes up. So even if you're just held because you're the wrong guy, if you're held for 3 days, your chance of getting a new criminal arrest goes up by 39%. And if you're held for 14 days, it goes up by 56%. And even over 2 years, if you're held for 14 days, it can go up by 51%. So that makes a lot of sense for anyone who has a loved one or has dealt with the criminal system, right? Just like Ashley said, if you lose your job, you lose your house, you lose your kids, you know, all of that starts to spiral.
Yeah,
and then we know that that can be really linked to getting arrested because of where people end up. So it's not just about human beings as well. It's a community safety issue, because keeping the community safe means getting people out of jail when we can get them out of jail.
Wow, those statistics are daunting. We all need to be at that subcommittee #2 meeting right now, sharing the same thing. But I know our colleagues are there doing the same thing. Brian, could you send the link to, let me see what this is. I'm reading from the chat. Could you send a link to the information in the chat to what you just posted?
Yes, I'm going to see if I can find an easily shareable link and pull that up.
Okay. Woo. Ladies and gentlemen, and Ashley, we're not just talking about people who may have criminal histories, may be used to dealing with the system. We're talking about people who could be stopped for traffic violations and get arrested, who have no knowledge of any of this. And how frightening would that all be to someone who is stuck in the system and doesn't have counsel when they first appear before a judge?
Yeah, our organization has worked with all sorts of folks from all different communities, people in all different circumstances. And I will say, even when you've had experience with the criminal justice system, it's like this shapeshifter. I mean, there's always new and different things that you could be presented with. So, I think it's a very complicated beast. And I really think having a judicial officer, an attorney with you at that first appearance, can change the temperature of the room when you're at your arraignment. And I don't know how else to say this, but like, it's just not fair. It's not fair that your life for the next however long is being decided, and you don't have someone who knows the system standing beside you as an advocate.
Let me see. We have another question. Sue Owens says she has questions, but unless you're a panelist, I think you have to put your questions in the chat. Will it make the let's see what this says. I always thought that people have to get access to a lawyer first appearance or actual trial. That's by David is asking that question.
So it's complicated, is what it boils down to. So for your trial, the Sixth Amendment to the United States Constitution says you have a right to a lawyer. And if you can't afford a lawyer, the court or the government has to give you a lawyer. But the question, the $1 million question, like everything else, is when does that start? So when is the answer? So people have probably heard the Miranda warnings read a million times in their life. And it says, if you want a lawyer present for your questioning, they can make that happen. So, but you have to ask for a lawyer at questioning. Then there's a case, now I think it's Gillespie versus Town of Rothbury, something, it's from the United States Supreme Court, that says that your arraignment, your first appearance, is a critical stage. And that's when the right to counsel attaches. That's when the Sixth Amendment begins. But the way that case is kind of borne out is it means from that day on, your right to counsel attaches. It's unclear, the case really hasn't been litigated enough around the country to determine whether it attaches at that hearing. And by attaches, I mean your constitutional right starts at that hearing. So you ought to have a right to counsel at that hearing, because when the law says a critical stage, it means something so important that you really need a lawyer to help you with it, because normal people couldn't do it themselves. And just like Ashley was saying, I'm the policy director with Justice Ford, Virginia. That's why I'm here. But my day job is I'm a public defender in Fairfax. I see it every day where the judge holds someone on a Monday at their arraignment with no lawyer. I go in on Tuesday to do a bail hearing and the person's released. And almost the only thing that's different is that that person has a voice, an advocate other than them. And it shouldn't be them, because you shouldn't be talking at all if you're accused of crime. To actually tell the judge, hey, this is where the person lives, this is where they work, this is their family. And then all of a sudden, magically, the person gets released. So that's the issue of you ought to have a right to a lawyer at that time, but you don't right now, unlike a trial.
We have another question from Wamik. I hope I'm pronouncing that correctly. Once arrested or exposed to the inequity of the justice system, you lose hope, and then social inhibition. And that's not a question, that's a comment. Ashley, would you like to address that?
I mean, I can't speak to that personally, but I certainly see this system. I think there are a lot of ways that you can, that a system can pronounce death on people. And one of the ways is through this kind of slow wearing down. So I certainly think that in this early phase, with all of these ways that people can get tangled up in that first initial part, I think certainly it would be difficult to maintain hope. I think that is a profound statement.
Donald Miner asks, he says, not to mention doctor's appointments, access to medications, and other things. Sue Owens asks, will it make the appointment of court appearance take longer if they have to wait for counsel? Question was from Senator Saslav's office. Woo! So Senator Saslav, one of the most long-standing and long-term members of the state Senate, and a very powerful player in this General Assembly, is asking, will it make the appointment of court appearance take longer, Brian?
So I think the shorter answer there is no. And again, that's the beauty of the bill. The kind of way this gets raised is, and there's another there was another question in the chat about the differences between rural counties and non-rural counties. I think it kind of comes in together here. So in the larger jurisdictions that have court every day, and there's a lot of lawyers, this should not be an issue at all, because there's always lawyers there, and lawyers should be able to be appointed fairly easily. Also, any jurisdiction covered by a public defender's office, which is not the whole state, it's only parts of the state, this will not be a problem because the public defender will be the main agency that deals with this. And the Indigent Defense Commission has basically said that won't be a problem. Public defenders are going to be able to handle that. So you're looking at mostly rural counties where there is not coverage by a public defender's office. And there's this idea that because there's not enough attorneys in those places, it will be hard to find someone. And if there's a requirement that there be an attorney at the first appearance, if you don't have an attorney, the case will have to be continued till there's an attorney there. So I think it's an uncreative way of looking at how we're going to do this. And again, the beauty of the bill is that each individual county or judicial circuit or district will come up with a plan. And there was a delayed enactment, I think, in the bill that gave everyone enough time to meet. It would be the chief judge, the sheriff, the Commonwealth's attorney, the public defender, if there is one, if not, a representative of the defense bar, the pretrial services agency. Everyone's going to get together and say, okay, the law says we have to do this. How are we going to do it? And most of those rural counties, they don't have court every day. So if you know court's on Friday and someone's going to have a first appearance, you're going to know most of the time, except for the people arrested late Thursday night or maybe early Friday. But you're going to have plenty of time to find an attorney who has a case that day, someone who's already on the docket. And if no one, call around to find someone to get an attorney there. And I think what will happen in most places will be that attorneys will volunteer to sign up. There are many counties and cities already doing this, including places without a public defender. Williamsburg, James City County does this. They don't have a public defender's office. They're a relatively small jurisdiction. Prince William County, before they had a public defender's office, was doing this. They're a large county. They have court every day, but it was logistically difficult to figure out a way, how can we get a lawyer there every day? And the way the court did it is they said, if you're going to be the attorney arguing for release at first appearance for people, you get first pick of taking those cases on a court appointed basis. So if you want those cases, you get them by coming in. It was a real benefit to people because lawyers who were looking to get those cases got the cases because they were there. So different locations are solving the problem differently. And I think that's the key. It's not going to get cases continued because everyone's going to come up with a plan to figure it out because that's the law. It'll just happen. And if there is a place where it keeps getting continued because there's no lawyers, that's where people are advocates or community members are going to have to step up and say this isn't fair and figure it out.
All right. Edward Strickler says, COPPA, counsel at first appearance, sounds like a great idea, but he asks, who will pay? Someone has to pay. Many rural counties have no tax base to pay. And most rural counties do not have oodles of resources to pay for this kind of thing. And okay, so how would we respond to that?
So the county or city does not pay. So people worried about that completely understand that is a real problem for a lot of parts that touch the criminal legal system among literally every part of government services in Virginia. But the way payment for counsel goes, it's not going to be locality based, it's state based. That still doesn't solve the problem of who's going to pay because people still have to pay. And we're not saying that this won't cost money, it will cost money. But what we are saying is that when you see the cost estimates from the Supreme Court, it's not going to be as much. And there's a few reasons for that. One is, the main thing is people who can afford their own lawyers are going to get their own lawyers there for first appearance. If I had to scrape together some money. I might be able to afford a lawyer for depending on what the charge was for a loved one. So they got arrested. I'd find someone immediately, say they have court tomorrow. Can you go get them out? It really boils down to, in terms of government services, people who can't do that, which is quite frankly most people, especially anyone who has anything remotely serious. So the big trap here is that people say, oh, each of these hearings is going to cost additional money, where it's not true. Everyone's going to get a bond motion anyway. So the cost of the bond motion should really be built into the cost of the case, which is abysmal, and court-appointed attorneys don't get paid enough. Separate issue, but it's we're doing it in every case anyway. People are asking for bail hearings anyway. The logistics of it mean that that might be a little different, because if I'm the attorney in a county and I'm going to go do everything that day, if I'm going to stay there for most of the day, talking to people, making phone calls, making arguments in court, I should be paid for that, even if I don't end up getting appointed to all of those cases. So there is a mechanism in the bill to have people get paid the court-appointed rate, which is $120 or $540, depending on, up to that, depending on if it's a felony or a misdemeanor. So there will be a segment of cases where someone has two attorneys, one for the bail hearing, one for the actual charge, and both attorneys will be billing for their time. So that will come out of the state money to pay court-appointed counsel, but that's something we should be doing because it's worth, what is a day of someone's life worth? And that we probably can't calculate. Lynn asked in the chat, isn't the cost for these attorneys offset by reduced jail time, or is that from a different source? And that's a huge problem. And not a huge problem, it's a problem for the accountants, not for human beings, right? So court-appointed funds come out of the state fund. Days of people's lives are spent in local or regional jails pre-trial. That money is a cost savings, usually to the county, the city, or the group of county or cities that pay into the regional jail. So it's a savings for the locality at a cost to the state. If the only thing we're economically counting is dollars that go into a state program right now. Again, what is the cost of not getting a criminal conviction? What is the cost of having someone lose their job? What is the cost of someone having lose their housing for people, and not just people on the border there, people in the huge chunk of society? If you lose that, you're going to be going to social services anyway, and you're going to end up costing the state a lot more. So the narrow look we have in terms of economic questions, when we look at these things, it's only within the system, only within the pot of money. We have to look broader than that. But it will be, again, it will cost the state money, no question, but it will end up saving localities money.
Wow, that's a lot. Ashley, listen, if I get arrested, I need to know how to reach the the community bail fund. How can we citizens reach your organization if we have questions about that?
Sure. So you can find us on the web at rvabailfund.org. And then I can put we have 2 phone numbers that I can put in our chat.
Okay.
That we're actually on an administrative break right now because we, over the since 2020, and this, I'm not quite sure how to calculate this in our this feels like algebra to me, but our bail fund has spent over $1.4 million in posting bails for people. Now that money, our fund is a revolving fund, which means that when I post bail for someone and that person comes to their court appearance and their case reaches a disposition, which means they're either found guilty or innocent and everything is wrapped up, that money comes back to our fund. So there is some revolve, if that makes sense. And we also do some paying for home electronic monitors and GPS systems and other things, but that's a lot of money that has been spent. And to me, feels like it could be other things could be done with that money. So I'll put our website and our 2 phone numbers. We have one phone number that people use to call when they're not incarcerated, and we have another phone number that is specifically set up so that folks can call when they are incarcerated.
Okay. We have another question from Edward Strickler. And there are 2 people who've raised their hands, but if you aren't a panelist, we can't see your raising hands. We can't bring you the camera. So you're gonna have to put your questions in the chat. But Mr. Strickler writes, with a similar reimbursement mechanism where localities organize and state budget pays, support rural and other areas to have otherwise unaffordable jail diversion programs, e.g., a mental health docket. What are the prospects of such a proposal?
So that is a little outside of my area of expertise. The state budget is something that I have literally never understood and don't think I ever will. But the state, through the Department of Criminal Justice Services, does give grants for some types of programs, especially some of the specialty courts or dockets, mental health dockets, veterans treatment dockets, things like that. But there is obviously this incredibly wide disparity between the rich part of the state and the poor part of the state, where the opportunities available to people in the criminal legal system in the rich parts of the state are so much greater than in other parts of the state, and it has a real impact on case outcomes and people's lives.
Wow. That's deep. So if anybody else that is watching or participant, please put your questions inside the chat. We're down to 10 minutes. Brian and Ashley, you all have shared a lot of information. Now, where do we go from here? Because we know that the bill is before the House Courts of Justice Subcommittee number 2. And we'll know about the outcome shortly. But we also have a bill in the Senate with Senator Jennifer McClellan. How can we best support that bill as well, Brian or Ashley?
So I think there's lots of things people can do right now. So first, it's up in the House of Delegates, like literally right now.
Right now,
the bill is being discussed. I don't know what will happen with that. No matter what happens with that, that will not be the end of it. It's going to start in the Courts or Judiciary Committee in the House and the Senate. If it passes through one of the subcommittees, it goes to a full committee. Full committee, either way, it will get referred to Finance or Appropriations, the money committees in both parts. And that's where the real fight has been. So we're going to need help advocating, especially if you are a constituent of someone on the Judiciary Committee in the Senate or the House Courts of Justice Committee. We need you talking to your legislators. It helps for everybody to talk, but the most important thing is individual constituents of those people. So if you know or are a constituent of Ronnie Campbell, Margaret Ransone, Ren Williams, Les Adams, Carrie Delaney, Charnel Herring, or Vivian Watts, those are on the House side. And then Judiciary, there's too many of them in the Senate, but it's people from all over. And then in Appropriations, it's going to be the same thing, the subcommittee and the full committee. So it's really getting people's legislators to understand how important this is, and that it's going to be worth spending the money because it's going to help our communities in the long run. The other thing I think I want to point out is even if it doesn't work this year, we're going to keep coming back to try it. And also lots of jurisdictions, as I mentioned, do this themselves already. You don't need a state statute to do this in your locality. You can advocate with the Commonwealth's attorney and with the public defender if you have one, and especially the Board of Supervisors, who are going to be the ones who can help fund this, or the sheriff. All of these people, the Commonwealth's attorney, the sheriff, and the boards of supervisors get elected. Or if you're in a city, the mayor or the city council. Advocate in your locality to start it, even if it doesn't pass this year, so that you're going to be ahead of the game and people's lives in your locality will be saved, and that money that you can save at the locality level can be saved, and you can help, again, your fellow community members, your economy, everything like that, and your families, and it will save some strain that the criminal legal system causes for the social services system, which can be on a county basis. So even if we need your help to win for everybody, but if we don't win for everybody, win for yourselves, and work on that between this year and next year if we don't prevail.
Well, in closing, we'd like to invite everyone to go to the Virginia Interfaith website. We have all of our legislative priorities on there, VICPP.org. You can find out, and we will be posting every day. We do alerts every day from the General Assembly. In fact, if I haven't heard from anybody before, right after we finish, I'm going to have to run back up that hill. I'm going to be in the best shape of my life because going up that hill and back down to Shockoe Bottom every day is a hump. In closing, Ashley, do you have anything to leave us with?
I just want to say, do what Brian said. I think it really will have a tremendous positive impact on our communities. I really believe that.
Yes,
So,
ma'am. Yeah. Brian?
I just want to shout out the bill numbers: HB 369, HB 369, that's Delegate Williams Graves, and SB 475, that's Senator McClellan. I put them in our little chat there, but those are the ones to watch. Again, no matter what happens today, there's still a lot of work to be done at the state and local levels.
Yes, sir. And ladies and gentlemen, thank you for your participation. At VICPP, we say learn, pray, but act. Action is going to be the order of the day. No participation, no right to cry and moan. If you fold your hands across your chest and say, I don't have anything to do with that, you're against humanity. No participation, no right to cry and moan. Ladies and gentlemen, thank you for your presence. Let's the people united will not be defeated. The people united will not be defeated. Carry on, soldiers.